I always figured if the cops ever showed up at my place at 7 in the morning, it'd be because I'd finally lost my mind, not because I took a snowmobile ride before breakfast. But there they were, red and blue lights flashing across fresh Minnesota snow like some kind of low-budget crime drama, except the only criminal on scene was apparently me, according to my HOA. I stepped outside in my thermal shirt and boots, breath hanging in the air, and there stood Sheriff Tom Anderson, looking annoyed enough to cancel somebody's Christmas. Behind him, lined up at the edge of my property like a firing squad of suburban righteousness, was Barbara and her little HOA posse, arms crossed, lips tight, already rehearsing their victory speech. Tom gave me that look, the "I'm only here because paperwork exists" look, and said, "Morning, Owen. Got a complaint. Illegal vehicle. Protected land. Disturbing the peace." I glanced at my snowmobile sitting exactly where I'd parked it after a quiet dawn ride through trails my grandfather built 40 years ago. Illegal vehicle. That machine had more environmental planning behind it than Pinewood Estates had in its entire design committee. Barbara marched forward, blonde hair pulled so tight it looked like it hurt. "I demand you cite him immediately," she snapped. "He's destroying wetlands." Destroying wetlands. I almost laughed, except I did laugh. That didn't help. What Barbara didn't understand, or maybe didn't care to, was that those trails were legal easements, recorded with the county in 1987 and renewed when my grandfather passed. They cut through land that developers later carved up into cookie-cutter houses with vinyl siding and dreams of HOA dominance, but the easements stayed. They were ironclad. Tom flipped through the documents I handed him, making a little show of it. "Everything checks out," he said. "He has legal right-of-way." Barbara's face went from pink to dangerous crimson. "This isn't over," she hissed. She was right. That morning was just the opening shot. By noon, Jim Patterson, my neighbor across the road, old-school Minnesotan with a gravel voice and a permanent smirk, called to warn me Barbara was going door-to-door collecting signatures to revoke outdated easements. Outdated. Like constitutional rights expire after 30 years. I called my lawyer, Mark Stevens. Calm, methodical, the kind of guy who could say pound sand in legal Latin. "They can't vote away recorded property rights," he told me. "But they can make your life expensive." That word stuck, expensive. Sunday morning I walked outside with coffee in hand and nearly choked on it. Someone had installed a giant private property, "No trespassing" sign at the trailhead 3 feet onto my land. Concrete base and all. They'd worked overnight. That's when something shifted in me. It wasn't about noise complaints anymore. It wasn't about a snowmobile at dawn. It was about someone deciding that if they pushed hard enough, I'd roll over. Tom documented it. I dug it up. Then I drove that sign straight to Barbara's house and handed it back to her. "You can protect your property," I told her quietly. "Just stay on your side of the line." She called it harassment. I called it geometry. The next week things escalated. Chains across trail crossings, locks on gates, vandalized truck tires slashed with "Stop the Noise" carved into the paint. That's when it crossed from petty to criminal. Then came the twist. Mark called me Monday morning. The HOA board minutes mentioned something interesting. They're planning a new community park, and your easement's cut straight through it. A park. A shiny little marketing brochure park. And suddenly all the noise complaints made sense. But it wasn't just the HOA. A few days later, a man in an expensive suit showed up in my driveway, shoes sinking into snow like he'd never met winter before. "Richard Hartley," he said. "Northland Development." That's when the real story walked into my kitchen. 300 new homes planned north of my land. Shopping center. School. Big expansion. My trails reduced the number of houses they could cram in. Less density. Less profit. He offered me $2 million. $2 million. That's the kind of number that rearranges your life. I won't lie, it rearranged my breathing for a minute. But while he talked about returns and ROI and progress, all I could see was my grandfather's old Polaris humming through those woods the way he'd stop at wetlands and explain how you route around fragile ground, how you use land without killing it. Money's loud, but memory's louder. I told him no. He smiled the way a man smiles before he buries you in paperwork. And he did try. They filed injunctions, claimed nuisance, brought in environmental experts. Legal bills stacked up so fast I had to take out a loan against my own property just to keep fighting. There were nights I stared at the ceiling wondering if stubbornness and principle were just 2 words for financial suicide. Then the hearing came. In court, Their lawyer painted me as some reckless redneck tearing up pristine land. Mark dismantled it piece by piece, easement records, maintenance logs, conservation office statements. Then he dropped the bomb. Every Pinewood homeowner had signed documents acknowledging the easements before buying. They knew. The board knew. And Northland had funded the HOA's legal fight. The judge's gavel felt like thunder when she denied their injunction. She ordered mediation. And something else, she looked deeply troubled by corporate manipulation. Public opinion started shifting. Hunters spoke up. Conservation Board issued a statement. Suddenly I wasn't the villain. I was the guy fighting a corporation. Mediation went nowhere. Northland raised the offer to $3 million. $3 million. That's generational money. That's never worry again money. I still said no. Then came the full trial. 3 days. Lawyers in suits whispering like sharks circling. Barbara sitting stiff as plywood. Hartley staring like I'd insulted capitalism itself. When I took the stand, their attorney asked, "You could end this by selling. Why won't you?" Because if property rights only matter when they're convenient, then they don't matter at all. The courtroom went quiet. 2 hours later, the judge ruled in my favor. Easements valid. Lawsuit baseless. Legal fees awarded to me. Then she referred the matter to the county attorney for investigation into bad faith and fraud. That's when Barbara stopped looking angry and started looking scared. The investigation moved fast. Turns out Barbara and 2 board members had been quietly receiving payments from Northland. Not disclosed. Not approved. Just tucked away. Bribes. They pled guilty. Fraud. Embezzlement. Harassment. Barbara did 6 months in jail. Northland settled civilly. $500,000 in damages to me and full redesign of their expansion around the existing trails. Funny how progress learns to bend when it costs enough. The new HOA board passed a resolution supporting the trail system. Publicly. Jim threw a barbecue that summer. Hunters, families, neighbors, even a few Pinewood folks who admitted they'd bought into the hype. Martha's cinnamon rolls nearly ended me. I used some of the settlement money to upgrade the trails, better signage, erosion control, long-term maintenance trust, so they'd outlive me. One winter morning after the first heavy snowfall, I rode out at dawn again. Same ridge where my grandfather and I used to stop. Engine idling. Wind quiet. I kept them, I told the air. Here's the thing I learned, and I didn't learn it cheap. Corporations talk about progress like it's destiny. HOAs talk about order like it's morality. But neither of those words mean a damn thing if they're built on trampling someone else's rights. Power tests boundaries. Money tests character. And sometimes the only reason something survives is because one stubborn person refuses to sign. When I pulled back into my driveway that morning, Jim was waiting with coffee. "You know," he said, "most folks would have taken the money." "Yeah," I said. "I know. But here's the question that still rattles around in my head. If I had taken the $3 million, would I have been wrong? Or just practical? Where's the line between protecting legacy and clinging to pride? I'd love to hear what you think. Would you have sold? Would you have fought? Have you ever had to stand your ground when the easy money was staring you in the face? Tell me, because out here, the snow keeps falling, the trails keep running, and the next fight is always just one development proposal away.